All right. Hey guys, how are you? I want to welcome you to today's training. It's entitled How to Protect Your Family and Assets from Uncertainty, Opportunists, and Probate Without Any Hassles. And thank you so much for being with me here today. My name is Lisa Haster, and I'm an estate planning attorney with the Metropolitan Law Group, PA. I'm excited for today's training. I think you're going to find it extremely beneficial to you and your loved ones. Let's see if I can get my PowerPoint here to cooperate. There we go. I want to tell you just a little bit about me. Here's a picture of my family and, of course, my dog, Olive Oil. So when I speak about protecting people's families, I do sincerely believe that you need to you really need to protect their interests in the event that something were to happen. And that's especially true when you're dealing with minor children. So you might be wondering who I am and why you should listen to me. I'm an estate planning attorney. I have 15 years experience. I don't know why this keeps jumping around on me here. Sorry about that. I've been practicing law for nearly 17 years, and I have educated other attorneys at continuing legal education seminars. I co-authored a Minnesota statute on asset protection. I am a leader in asset discovery and the protection of assets. I recently won a landmark case in a garnishment exemption matter, which again is asset related. I'm a two-time publisher, including author of How to Protect Your Family from Uncle Sam, Opportunists, and Uncertainty by Avoiding Probate. I wasn't always an estate planning attorney. I did a little bit of estate planning here and there, but my primary area of practice was collections litigation. And what that meant is that I was suing people who were not paying their bills on behalf of credit card companies, banks, and lenders. And as you can imagine, it's pretty easy to wear out in collections litigation. The litigation aspect is bad enough, but when you're dealing with people whose paycheck you just garnished or whose bank account you just wiped out, you can imagine it gets old very quick. Every phone call I took was met with anger. It was a bad karma gig, and I knew I needed to do something else. I wasn't sure where I would turn, and then I had some very unsettling news. I learned that my best friend and my brother had passed away just within a matter of months of one another, and they were both in their 30s. It was very unexpected, and I experienced at that time firsthand the hassle that a family has to go through to weed through assets to determine what bills get paid, what to do with bank accounts, because of course neither of them in their mid-30s had done any end-of-life planning, like way too few people failed to do. And it resulted in a lot of discourse during a grieving time that's already tough. But that made my mission clear. After going through that, I knew exactly what I wanted to do with myself, and that was be an estate planning attorney to make sure I could help other families avoid the headaches that my family and my friend's family had to go through due to lack of planning. So when I decided to make estate planning my primary area of practice, I didn't just go to a continuing legal ed course or pick up a book like many attorneys do when they're trying to figure out a new area of practice. Instead, I instilled the help of Alexis Neely. And Alexis Neely is really a nationwide, she's a very well-known estate planning expert. You may have seen her recently talking on the news about Prince's estate. She is a commentator on Fox News and on CNN and the morning show, and she's the author of Wear Clean Underwear. I worked for her and did nothing but working underneath her guide for 3 months in order to really learn all of the insides and outside of trust-based estate planning. Let's get right to it, guys. So now we're going to talk about the 3 secrets that we'll be covering in today's training. Those 3 secrets are probate, why it might not be the easiest or the cheapest route for you and your loved ones. The second secret is that estate planning is critical to every parent, provider, and professional, regardless of what kind of assets you've got and regardless of your age. And then finally, the third secret, healthcare concerns. A healthcare directive is not going to take care of your concerns if you're incapacitated. You're going to learn that there's more you need to do today. First, I want you to understand the difference between wills and trusts. And this is because I have so many people who come to my office and tell me they want a will. And then when I ask them why they want a will, they tell me, well, to avoid probate. And I said, well, a will will take you straight to probate. So maybe it isn't a will that you actually want. So I always make sure that my clients understand the differences between wills and trusts. A will is really a roadmap for a probate judge. So if you've got a will, your estate will be probated. And that means that the final decision as to how your assets are going to be divided is left up to a probate judge. He or she is simply looking at your will to determine what your wishes were. But the final say is left up to the probate judge. A trust, on the other hand, I want you to think of it as bubble wrap. You're going to take all of your assets and you're going to bubble wrap them. So a trust is really a legal document that is going to assist you in avoiding probate so that your family can stay out of court and out of conflict. Okay? Those are the differences. Secret number one is probate, why it might not be the easiest and the cheapest route for your family. And I get so frustrated when I see practitioners, other estate planning attorneys advising people who should not have any business with a will-based estate plan. They're telling them to go ahead and to go about it that way, just to get money in the door. And it irritates me to no end because they're really doing a disservice to their clients, in my opinion. If the ultimate goal is to avoid probate, then a will-based plan is not going to achieve that goal. So it's important to me to educate my clients on the differences so we can make sure that we do achieve those goals that they're seeking. So why it might not be the cheapest or the easiest route. And how to avoid probate. You have to, in order to avoid probate, one of two things has to happen. You either have to have assets that are less than $175,000, and that does include the value of your home. And then the other way, if you've got more than $175,000 in assets, the other way is going to be to create a trust-based estate plan. So people always approach me about the cost of a trust because trusts are not, they're not inexpensive. There's no doubt about that. But I always tell my clients, in the long run, it's going to pay for itself time and time and time again, many times over. And that's because although it might be cheaper for you to hire an estate planning attorney to draft you a will than it is a trust, it's cheaper on the front end. It's way, way, way more expensive to probate an action than to deal with the almost no administration at all, in most cases, that goes along with a trust-based plan after someone passes away. I was at a CLE, a continuing legal ed course a while ago, and I believe that one of the speakers mentioned that the average cost in my area, in the metropolitan area, to probate an action is about $46,000. I don't know many people who, as a personal representative of their parents' estate, just happen to have $46,000 kind of laying around just in case something happens. But that's the reality of things. And that, of course, you also have to look at the attorney's fees, right? The attorney's fees can end up being a huge headache, and the personal representative in most cases has to front those fees. And sure, at the close of the estate, they, of course, will likely be reimbursed for those fees. However, where I'm at, and this could probably vary from state to state, but where I am here in Minnesota, you're looking at on average about a year and a half before a probate action is closed. So that's a year and a half before your personal representative will be reimbursed his or her fees that they fronted. A trust, on the other hand, costs a little bit more upfront, but there's little to no expense upon death, and that's because the action is never reviewed by a court. The action does not need to go before a lawyer. It simply just takes effect immediately upon someone's passing. The estate planning objections I hear all the time are, I'm too young, or I have more debt than I have assets. And I get that, you guys. I went to law school and had some pretty stiff student loan debt when I graduated. So I get it. I also hear it's only for the wealthy. And you guys, this is wrong. This is the second secret. Every parent, provider, and professional needs estate planning to protect their family and their assets and their profession. If you're a professional like me, if you're someone who has to obtain professional errors and omissions insurance, or some type of professional insurance like a dentist or an accountant, a doctor, you definitely need to get on board with some estate planning and get those assets in a trust so that if something happens to you and someone sues you for malpractice, you can protect those assets. Here it is. I got ahead of myself. Secret number 2. Even if you don't have many assets, you need to be engaging in estate planning. And this is particularly true for parents of minor children. The reason being is, like I said, if you don't have a trust-based plan, you just got a will and you've named guardians for your children, that's a really good starting point, okay? But remember what I said about any action that is probatable. The final decision is left up to a judge. So it's very possible that you could name guardians in your will for your minor children. And then after you pass and your will is probated, the judge or the probate referee can simply assign someone else custody of your children simply because he or she believes it's in your children's best interest to go live with that particular person as opposed to the person that you designated in your will. And by putting together a trust-based plan, you alleviate that from ever being the case. And I mean, every family has one bad seed, right? I know mine does. And you have to imagine that person in your family who probably looks good on paper, but who may not have it all together. Maybe they're in a bad marriage. Maybe there's some addiction issues that you wouldn't want your children to witness. Those are all things that a judge will never know. A judge will never know the reason that you chose an individual to raise your children in the event that you can't. So if you're going to stick with a will-based estate plan, you have to know that if you have minor children, there is always a possibility that those guardians you appoint are not going to be ultimately the people who raise your children. And again, the importance of estate planning, and specifically trust-based planning, is that, with trusts, you can alleviate the risk of lawsuits, divorce, creditors, future marriages. And by that, I mean, if you have let's say you have a son who's an adult and he's marrying a gold digger. And, if you pass and you don't have your estate set up correctly, and your son ends up getting married and then ends up getting divorced, your I guess she would become the ex-daughter-in-law, is going to be privy to half of your son's inheritance. But if you do proper estate planning, you can set it up to avoid that. Additionally, we are minimizing risk of car accident, payouts, bankruptcy, any type of opportunist, and for those of you who are wealthy, excessive estate taxes at both the federal and the state level here in Minnesota. Secret number 3, this is our final secret, you guys. It is regarding healthcare concerns, and there is a misconception, and I gotta blame the doctors out there because a lot of people come to me and they say, "Well, I've got a healthcare directive. My doctor handed one out to me before I went in for surgery or when I was in for a visit." Um, the reality is a healthcare directive is a great start, but you need to do some additional family. I'm sorry, some additional family. Oh, I'm reading my slide here. You need to do some additional planning in order to put your family at ease. That's what I meant to say. So let's talk about what kind of healthcare documents are really needed. Okay, so along with the healthcare directive, and the healthcare directive is really outlining your wishes regarding your health care in the event that you're incapacitated, okay? But along with that, you also need to have in place a power of attorney, because if you're incapacitated, it's more than likely that you're not going to be able to handle your legal affairs, make your mortgage payment, make sure the bills get paid, and you don't come out of the hospital learning that your house is in foreclosure. So the power of attorney is going to allow you to designate someone to handle those affairs for you in the event that you cannot. You also are going to want to have, a HIPAA waiver. And the HIPAA is a federal privacy law, and it prohibits doctors from sharing medical records with third parties, okay? So if you make someone your healthcare power of attorney and they don't have a HIPAA waiver signed, how are they going to make sure that they're making the best decision and that they're following your true wishes with respect to your healthcare if they can't access your medical records, okay? So the doctor can give an opinion, but in a lot of cases, you want to make sure that the treatment that the doctor is suggesting is going to mirror what your intentions are that are laid out in your healthcare directive. So in addition to that directive and that healthcare power of attorney, you're going to need a HIPAA waiver as well. And then finally, I always throw in disposition instructions too. And I know that's sort of morbid and some clients don't want anything to do with it. Others get a complete kick out of it and they plan all the music and what kind of flowers they're going to have at their funeral. There's all different kinds of people. I had one guy who put together the Facebook post that he wants to go out when he passes. But disposition instructions are simply funeral instructions, letting your loved ones know, how much money you want to spend at your funeral. If you don't want any money spent, if you want an open or closed casket, if you've got some kind of religious preferences that you want to be touched upon, all of those things are going to be outlined in the disposition instructions. And once you've got all these documents in place, you can rest assured that your family is going to be put at ease, because if something does happen to you, they won't be scrambling to figure out what to do and how to get this stuff executed when it's just too late because you're incapacitated. There you go. How does it feel? How does it feel to have the peace of mind? What would that feel like for you, knowing that if something were to happen to you, your spouse, your significant other, your family would be taken care of no matter what? It's got to feel good, right? So I am going to make an offer to you today, and that is my Ultimate Family Wealth Protection Planning Consultation. And normally I charge $300 because for a couple, it usually takes about 2 hours for us to navigate through the strategy session. And for an individual, it usually takes about 1 hour. So the average price I charge is $300 for that. However, you are in luck because today, since you watched this wonderful training, I'm going to reward you by waiving my $300 strategy session fee, okay? And that is, of course, if you act by the end of the month. So make sure you make that call right away, you guys. And I've also got for you some free bonuses with any trust-based purchase. So if you buy any type of trust-based plan at all and you do it before month's end, or just, you just have to set up the appointment before month's end. You don't have to expect to get in and everything. Just make the appointment by month's end. and we'll get you scheduled, and you can take advantage of all of these free bonuses. And this is really a big deal, you guys. So we talked about the importance of all of these healthcare documents that you need. Normally, you can see we charge $500 for healthcare directives, $250 for healthcare power of attorney, $100 for HIPAA waivers, $250 for durable powers of attorney, and $100 for disposition instructions. So altogether, that's $1,200 that we are going to knock off your plan. Okay, so $1,200 of free bonuses for an individual, and this ends up being $2,400 that you're saving for a couple. So this is a really great opportunity to act on this, you guys. Okay, so, and I'm also going to offer you the planning session at a 100% risk-free guarantee. And that means that if you find that the Ultimate Family Wealth Protection Consult, or what I've been referring to as the strategy session, isn't worth you and your spouse's time, well, then you let me know, and I will go ahead and donate $100 to the charity of your choice. So there we have it, you guys. I want to thank you all for joining me on today's training. Hopefully you've learned a lot. If you'd like to ask me any additional questions, you've got my email address, my email address right there. I've also laid out my phone number if you want to get that scheduled right away yet this month, so that we can take advantage of all of those free bonuses and all the healthcare documents that come with it. By all means, make sure you do it right away. You can call our pre-recorded number, 612-524-9414, and we will get back to you with a date to have you come in, schedule that strategy session. Thanks so much, you guys. Take care.